minutes, and then we'll go into, I'll ask one question, they can all take a bite of that question, then we'll go right to you for more questions.
We're actually going to go reverse.
Okay, we're going in reverse order, I'm sorry. Andre.
Thank you, Ruben, and thank you for the Institute for inviting me today to speak. So my job is to give a background of local law enforcement with an emphasis on SB1070 copycat laws, and I think Ruben's only given us 7 minutes, so we'll try to be really quick and save time for questions. So, you know, SB1070 is a law passed by the state of Arizona in 2010. I'm sure a lot of you all are familiar with it. It was incredibly popular and controversial, and really was something that we did not anticipate to really catch fire in this country in terms of people's feelings about it. But SB 1070 was not an entirely new idea. Local law enforcement of immigration law has been around for a very long time, and we won't get into that today. And then in your other panels, you'll hear about other forms of local encroachment into the area of immigration law in terms of housing and employment, so we also won't touch on that. But what we saw, I would say, in this past decade is a trend towards an increase in local law enforcement agencies engaging in immigration enforcement. Now, this can either be independent, or this could be through cooperation with the federal government through what's called a 287G agreement. But what we saw through politics and through sort of the culture of a lot of localities is that local sheriffs and police officers were creating policies in which officers were engaging in immigration enforcement. Now, SB 1070 came along in 2010 and actually put all this down in writing. And what it said was officers are now required to engage in this enforcement. So the sort of main provision, probably the most widely known, is that when an officer stops an individual on the street, if that officer develops reasonable suspicion that the person is here unlawfully, then the officer must detain the individual until that person's status is verified. And you know, the title of this panel is really sort of captures it. It's Unreasonable Suspicion. A little play on words, but it really captures what the problem is. You know, it's unreasonable to believe that an officer who is untrained in immigration law is actually going to be able to enforce something that's incredibly complicated, that requires a huge amount of training and expertise in order to be able to effectuate it properly. It's unreasonable to believe that an officer is going to somehow develop suspicion that a person is here unlawfully in a way that's constitutional. You know, it's obvious that, you know, officers who are untrained are going to rely on unconstitutional factors such as a person's appearance, how they speak, how they're dressed. You know, it's unreasonable, and now in Alabama, which we'll discuss shortly, to believe that officers won't use this law and abuse this law to detain individuals who are here lawfully present, who are citizens. So I really think that the title of this panel is appropriate and really captures what our arguments have been in these cases. So some other provisions of SB 1070 is that one provision provides a presumption of lawful status if an individual provides certain state-approved identification documents, so a driver's license. And this really is what is really part of the ACLU's main argument, is that it creates a show-me-your-papers state. So now, say if someone who appears to be foreign, perhaps, leaves their license at home, is driving, gets stopped, who's to say that the officer is going to believe that they're here lawfully or unlawfully, and there's an increased likelihood that that person's going to be stopped. SB 1070 also created new state-based immigration crimes, which are completely independent of federal discretion and control. They attempt to sort of mirror what federal immigration law requires, but it places the prosecutorial discretion and judicial discretion entirely with the states and doesn't allow the federal government to sort of say, these are our priorities, we don't want to go after this person or that person, or this is the person that we want to prioritize. And SB 1070 also created also criminalize certain solicitation of employment. So after SB1070 passed, the ACLU, MALDEF, the National Immigration Law Center, and other organizations sued to stop that law from going into effect, as did the federal government. The law was enjoined, and that was upheld by the Ninth Circuit. But shortly after, in the 2011 legislative session, more than 20 states took up immigration laws similar to SB 1070. And I think there's a map in your materials of which states had those laws, which ones passed, which ones were defeated. And 5 laws passed, and as Ruben mentioned, those are in Utah being the first, Georgia, Indiana, Alabama, and South Carolina. But a lot of states, and a lot of states they failed, a lot of states that we thought they were certain, Texas and Tennessee and Mississippi, and those are for a variety of reasons, including strong coalitions, unlikely allies with the business community, AGs who issued opinions about the constitutionality of these laws. So it was sort of interesting and unpredictable in which states that were going to pass and which weren't. And sort of Utah caught us by surprise because historically, Utah, as sort of a predominantly Mormon state, has had a relatively good relationship with the immigrant population, particularly the Latino community. So these laws that passed in the 5 states after SB 1070 were modeled after Arizona's law, but each sort of tried their own way of kind of changing it, trying to withstand constitutional scrutiny. And for example, Utah and Georgia didn't include the same mandatory verification check as in Arizona on reasonable suspicion. They sort of created it differently. Sometimes it's mandatory, sometimes it's different. It can depend on what you're charged with. So each sort of created their own scheme. But each was sort of modeled under that, like, let's expand the law enforcement capabilities of local jurisdictions to engage in enforcement. And these states were all clear, and they sort of all followed the reasoning behind Arizona. The federal government is not doing enough for immigration. States need to step in. We want immigrants to self-deport. We want to create attrition by enforcement. They're all very clear about this. And then came Alabama. And this sort of blew everything out of the water, and they were very clear about it. They said, this is Arizona with an Alabama twist. And they basically said, we are going to make life so miserable for immigrants in the state of Alabama that they will leave. And the governor came out and said, this is the strongest immigration bill in the country. And it is. And it went well beyond law enforcement measures. It includes measures that go as far as making contracts with someone who is without lawful status to be unenforceable in state court. It criminalizes business transactions with local agencies and state agencies. And it required students, and in some cases their parents, to prove their lawful status when they're enrolling in school. And the ACLU and other organizations sued to stop that, as well as the Department of Justice. And part of it went into effect. We had a mixed ruling. And it was the first time that we had seen one of these laws go into effect, because up until then, things had either been stayed or enjoined. In Georgia, the law was blocked. In Utah, the law is stayed pending argument. In Indiana, the law was blocked. And in South Carolina, the law still hasn't gone into effect. So this was the first time that we saw it actually being placed into practice. And it was chaos. Some provisions are still in place. We filed an emergency motion with the 11th Circuit to enjoin a lot of the law, and some additional provisions were enjoined. But during those few weeks, Alabama was gripped in crisis. We saw thousands of Latino students not show up to school. We saw teachers asking students about their lawful status, about the lawful status of their parents. We saw workers not show up for jobs. People who have been working in these communities for 20 years just not show up and leave, sell their homes, or leave their homes. We have verified reports of water companies saying in order to start your water service, you need to provide proof of lawful status. The same for electric companies, landlords telling tenants that their leases aren't going to be honored. And it goes on, and we have a hotline set up, and each day it's a new issue. You know, is my marriage valid? Does a notary need to ask people whether they're lawful lease? It just goes on, and I don't think anyone really imagined what was going to happen. And so just to quickly wrap up, I think where we're going is sort of unclear. The Ninth Circuit has petitioned for cert with the Supreme Court. I mean, the state of Arizona has petitioned for cert with the Supreme Court on the SB1070 case. The court has not decided whether they're going to take it up. But we've seen, really in the past few days, a very interesting event happen. Russell Pierce, who was one of the primary sponsors of SB1070 in Arizona, was recalled. And so I think that made some message saying, look, the electorate may not be behind this. You may be able to spark this sort of controversy, get the votes, but in the end, this may turn on you. But then on the other side, there were a lot of states where the Republican Party took control. This is on SB1070, copycat laws, and I think Ruben's only given us 7 minutes, so we'll try to be really quick and save time for questions. SB1070 is a law passed by the state of Arizona in 2010. I'm sure a lot of you all are familiar with it. It was incredibly popular and controversial, and really was an area of immigration law in terms of housing and employment, so we also won't touch on that. But what we saw, I would say, in this past decade is a trend towards an increase in local law enforcement agencies engaging in immigration enforcement. Now, this can either be independent, or this could be through cooperation with the federal government through what's called a 287G agreement.
And then we'll go into, I'll ask one question, they can all take a bite of that question, then we'll go right to you for more questions.
We actually want to go reverse.
Okay. We're going to go in reverse order, I'm sorry. Andre.
Thank you, Ruben, and thank you for the Institute for inviting me today to speak. So my job is to give a background of local law enforcement with an emphasis, something that we did not anticipate to really catch fire in this country in terms of people's feelings about it. But SB1070 was not an entirely new idea. Local law enforcement of immigration law has been around for a very long time, and we won't get into that today. And then in your other panels, you'll hear about other forms of local encroachment into the, but what we saw through politics and through sort of the culture of a lot of localities is that local sheriffs and police officers were creating policies in which officers were engaging in immigration enforcement. Now, SB1070 came along in 2010 and actually put all this down in writing. And